A property tax exemption is a release from the obligation of having to pay taxes on all or part of a parcel of real property. Personal exemptions are enacted to reduce taxes of individuals due to a particular personal circumstance. As with exemptions for property, the applicant must demonstrate that he or she clearly meets the requirements of the exemption. Exemptions are granted for just one fiscal year. The taxpayer must apply each year to receive the exemption for that year. We will cover the personal exemptions available to the following individuals: seniors, veterans, blind persons, surviving spouses, minor children of deceased parents, and persons with financial hardships. If a taxpayer files a timely application and meets all the qualifications for a personal exemption, you must grant the exemption. However, as we will discuss later, you have discretion in deciding whether to grant a Clause 18 hardship exemption or a Clause 18A hardship deferral. A taxpayer denied a personal exemption or deferral other than Clause 18 or 18A may appeal the denial to the Appellate Tax Board. The qualification date for a personal exemption or deferral is July 1st, which is the beginning of the fiscal year. The taxpayer must meet the ownership, domicile, age, and any other eligibility criteria as of that date. If the applicant does not meet all qualifications until sometime later in the fiscal year, the taxpayer must wait until the next fiscal year to receive the exemption or deferral. A taxpayer must apply each and every year as some circumstances relating to his or her eligibility for the exemption or deferral can change. The application is due April 1st or 3 months after the actual tax bills are sent, if that date is later. You cannot grant an exemption or deferral if the taxpayer does not apply by the deadline. Exemption and deferral applications are not open to public inspection. The information contained in the application and any supporting documents is confidential. However, you must maintain a record of all exemptions and deferrals granted. That is a public record. The information you must include in that record book can be found in General Laws, Chapter 59, Section 60. All applicants for a personal exemption or deferral must meet certain requirements. First, the applicant must own the property. Some exemptions or deferrals also have a durational ownership requirement. That means the applicant must have owned the property or other property in Massachusetts for a minimum number of years. Second, the property must be the applicant's domicile. Some exemptions or deferrals also have a durational domicile requirement. The applicant must have been domiciled in the property or other property in Massachusetts for a minimum number of years. To learn which exemptions and deferrals have durational ownership or domicile requirements, click the button to view the Exempt Persons, Ownership, and Domiciliary Requirements table in Chapter 7 of the Course 101 Handbook. Third, the applicant must meet certain requirements related to his or her personal circumstances, such as being a certain age or a veteran. These circumstances are the reason for the legislature deciding to provide the taxpayer with an opportunity to reduce or defer the taxes owed. Fourth, the applicant must document that he or she meets all qualifications for the exemption or deferral. You may request any documentation reasonably necessary to ensure the applicant is qualified. The taxpayer must demonstrate that he or she is entitled to the exemption or deferral. As we just learned, an applicant for a personal exemption or deferral must have an ownership interest in the property. The applicant can be the sole owner or own the property with a spouse or others. We are now going to look at 2 other forms of ownership you will likely see from applicants for personal exemptions or deferrals. The first is a life estate. A life estate is ownership of real property for the duration of a person's life. In legal terms, it is an estate in real property that ends upon the death of a person, at which time ownership of the property reverts to the original owner or passes to another person. The owner of a life estate is called a life tenant and has the present right to possess, use, and occupy the property. The person who will succeed to ownership sometime in the future when the life tenant dies is called a remainder man. The typical situation you will see is shown in this example. Mary, a senior, conveys her domicile to a family member, here her son John. In the deed, Mary reserves a life estate to the right to live in the property during her lifetime. John holds a remainder interest. As holder of the life estate, Mary is the assessed owner and the owner for personal exemption or deferral purposes. As a life tenant, she has an interest in the property during her lifetime that is sufficient to meet the ownership requirement. The second form of ownership is a trust. A trust is a form of ownership in which one person holds legal title to property and has a fiduciary obligation to use it for the benefit of another. A trust divides the interest in property into 1. A legal interest, held by the trustee, and 2. A beneficial interest, held by the beneficiary. A common situation is shown in this example. Tom, a senior, creates a trust. His children are the trustees, and he is the beneficiary. Tom transfers his domicile to the trustees of the trust. His children hold legal title to the domicile as trustees. Tom has only a beneficial interest in the domicile. In order for Tom to be an owner for personal exemption or deferral purposes, however, he must have both legal title and a sufficient beneficial interest in his domicile. Since Tom is not a trustee, he is not an eligible owner for an exemption. If Tom and his children were the trustees, though, he would have both legal title and a beneficial interest in his domicile and would qualify as an owner. As we have also learned, the property must be the applicant's domicile. Domicile is the status of being a lawful permanent resident in a particular place. Domicile is a legal term and consists of 3 elements: actual physical presence at a fixed dwelling place with the intention to remain permanently. It is the applicant's principal and legal home. It is the place where family, social, civic, and economic life is centered and where the applicant plans to return whenever he or she is away. Domicile is determined based on an analysis of all facts and circumstances related to the applicant's principal and legal residence. Factors to be considered would include where the applicant votes, registers a car, spends most of his or her time, replies to the census, files tax returns, and has ties to the community, such as where the applicant's spouse and children live, and where memberships in churches, clubs, and social organizations, and where bank accounts are maintained. A person can have many residences, but only one domicile at a time. A person establishes a domicile, and that remains his or her domicile until a person takes steps to establish another place as his or her permanent and legal home. A frequent issue is whether taxpayers who are confined to a nursing home, rehabilitation facility, or other long-term care facility have changed their domicile. Not necessarily. You have to determine whether the applicant intended to abandon the house as his or her domicile. However unlikely a return to the taxpayer's own home may be, the taxpayer may wish to move back if it became possible, especially where the home continues to be occupied by a spouse or other family member. If the confinement is permanent or the house is rented, for sale or vacant for a number of years, however, that may indicate an intent not to return, and that property is no longer the taxpayer's domicile. Age is a requirement for some exemptions. For example, a senior exemption is for a taxpayer who is at least 70 years of age as of July 1st. A taxpayer who is at least 65 years of age as of July 1st is eligible for a senior tax deferral. Hardship exemptions are for older persons, which generally means persons who are at least 60. Exemptions for minor children are for those under the age of 18. Some exemptions or deferrals require the taxpayer to provide specific certificates or other documentation. For example, a taxpayer seeking a disabled veteran's exemption must supply a certificate or benefit statement from the U.S. Department of Veterans Affairs, or a letter from the branch of the Armed Forces where the taxpayer served documenting the service-connected disability. A taxpayer seeking a blind exemption must provide a certificate from the Massachusetts Commission for the Blind. In the first year the taxpayer applies, a statement from a doctor that the taxpayer is legally blind may be substituted. A taxpayer seeking a senior exemption or deferral must provide a birth certificate, passport, or other document showing his or her age. Now, let's learn about local property exemptions for seniors. The primary exemption for seniors is found in Clause 41 and local acceptance clauses 41B, 41C, and 41C1/2. They provide exemptions to seniors who meet specific ownership, residency, income, and asset requirements. Clause 41 is in effect unless your city or town has accepted one of the local option clauses. Generally, the optional clauses have higher income and asset limits. Seniors must be 70 or older as of July 1st to apply for this exemption. Note that for clauses 41C and 41C1/2, the eligible age may be reduced to 65 or older by vote of the legislative body of the city or town. Also note that seniors 70 or older who do not qualify for one of the Clause 41C exemptions may qualify for an exemption under Clause 17 or Local Acceptance Clause 17C, 17C1/2, or 17D instead. Those clauses provide a lower exemption benefit but have less strict eligibility requirements. As we learned earlier, some exemptions also have durational ownership and domicile requirements. The senior exemptions under local option clauses 41B, 41C, and 41C1/2 all require that the applicant have owned and occupied their current domicile or other property in Massachusetts as a domicile for any 5 years, and been domiciled in Massachusetts for the 10 consecutive years immediately before the fiscal year the applicant applies for exemption. Applicants for senior exemptions cannot have received income above certain limits during the prior calendar year. This gross receipts test applies to income derived from all sources. It is not the same as taxable income for federal or Massachusetts income tax purposes. Each clause has a different gross receipts limit. An applicant's gross receipts include wages, salaries, and other forms of earned compensation, public and private pensions, Social Security, alimony, child support, lottery winnings, interest and dividend income, capital gains, net income from business or rental property after deduction of related business expenses and losses, public assistance, disability payments, unemployment compensation, workman's compensation, regular cash or financial contributions or gifts from family or other persons outside the household, and any other income. When determining whether a senior qualifies for a senior exemption under clauses 41, 41B, and 41C, you deduct from the gross receipts reported by a senior who received Social Security payments in the prior calendar year an amount established by the Department of Revenue. This amount, known as the Social Security deduction, is issued every year in an informational guideline release. It is adjusted annually by an increase given to Social Security recipients. Please review this example of the amount deducted for an applicant who is single and the amount deducted for the combined gross receipts of a married applicant and his or her spouse. Then click the next arrow to continue. This example shows the gross receipts limit for seniors applying for a Clause 41C exemption. Clause 41C has been accepted by and is in effect in most cities and towns. Note that any co-owner who is not the applicant's spouse must also meet the gross receipts limit for the applicant to qualify for the exemption. For Clause 41C, the gross receipts limit for applicants can be adjusted by the vote of the legislative body of your city or town. To learn about the adjustments that may be voted, click the button to view the information in Chapter 7 of the Course 101 Handbook. Please review the example, then click the next arrow to continue. Applicants for senior exemptions cannot have whole estate above certain limits on July 1st. Whole estate means all assets to which the applicant has legal title and access as a sole, joint owner, or trustee that contribute to his or her total worth and may be liquidated to pay debts and bills, acquire other assets, or leave as inheritances. Each clause has a different whole estate limit. An applicant's whole estate includes the value of the applicant's ownership interest in real estate, the value of personal property, cash on hand in checking and savings accounts, the value of stocks, bonds, money market, and individual retirement accounts or loans receivable, and the balances of private pensions or 401k accounts once the applicant legally qualifies for distribution. This example shows the whole estate limit for seniors applying for a Clause 41C exemption. Again, Clause 41C has been accepted by and is in effect in most cities and towns. Note that any co-owner who is not the applicant's spouse must also meet the applicable whole estate limit for the applicant to qualify for the exemption. Also note that in calculating whole estate, the value of the domicile, cemetery plots, registered motor vehicles, clothing, and household furnishings is excluded. For clauses 41C, the whole estate limit for applicants can be adjusted by vote of the legislative body of your city or town. To learn about the adjustments that may be voted, click the button to view the information in Chapter 7 of the Course 101 Handbook. Please review the example, then click the next arrow to continue. Note that under Local Acceptance Clause 41C1/2, there is no whole estate test. In addition, the gross receipts limit is tied to the maximum income a single person who is not the head of a household may have to qualify for the circuit breaker state income tax credit for that year. The Department of Revenue establishes this amount annually for state income tax purposes. As background information, the circuit breaker is a state income tax credit for Massachusetts senior citizens age 65 and older. It's called the circuit breaker tax credit because it is triggered like an electrical circuit breaker when a senior's property tax payments exceed 10% of the senior's annual income. Please review the example, then click the next button to continue. Previously, we noted that seniors 70 or older who do not qualify for one of the Clause 41 exemptions may qualify for an exemption under Clause 17 or Local Acceptance Clause 17C, 17C1/2, or 17D. Those clauses also provide exemptions for surviving spouses and minor children with a deceased parent. Clause 17 is in effect unless your city or town has accepted Clause 17C, 17C1/2, or 17D. All four Clause 17s require the applicant to own and occupy the property as his or her domicile and have assets within a certain limit on July 1st. In calculating whole estate, the value of cemetery plots, clothing, and household furnishings is excluded. Depending on the clause, some of the value of the domicile and the unpaid mortgage on the domicile and other real property is excluded. The exemption under all four clauses is $175. The exemption amount can be adjusted by vote of the legislative body of your city or town. To learn about excluded amounts and exemption adjustments that may be voted, click the button to view the exempt persons, whole estate, seniors, surviving spouses, minor children table in Chapter 7 of the 101 Handbook. If a taxpayer is applying for one of the Clause 17 exemptions, due to being at least 70 years of age, the applicant must also meet certain durational ownership and domicile requirements. Those requirements do not apply to surviving spouses and minor children with a deceased parent who apply. To learn about the durational ownership or domicile requirements that apply to each clause, click the button to view the exempt persons, ownership and domicile requirements table in Chapter 7 of the 101 Handbook. This example shows the whole estate limit for seniors, surviving spouses, and minor children with a deceased parent applying for a Clause 17D exemption. Clause 17D has been accepted by and is in effect in most cities and towns. Please review the example, then click the next arrow to continue. A surviving spouse of a police officer or firefighter killed in the line of duty qualifies for a full exemption from taxes on property owned and occupied as his or her domicile. There are no income or asset limits. The exemption ends upon remarriage. The surviving minor children of a police officer or firefighter killed in the line of duty also qualify for a full exemption from taxes on property owned and occupied as their domiciles. A minor child is under age 18 years old. There are no income or asset limits for this exemption either. Veterans may be eligible for a number of different exemptions. When a veteran's domicile is owned by his or her spouse, the spouse is eligible for the exemption instead. Some exemptions are also available to surviving spouses of veterans or surviving spouses and parents of service members. To qualify for exemption, a veteran must have been discharged under honorable conditions and have been domiciled in Massachusetts for the 6 consecutive months immediately before entering the service, or the 5 consecutive years immediately before the fiscal year the veteran applies for exemption. The 5-year requirement may be reduced to 1 year if the legislative body of your city or town has accepted this local option. We will review the listed veterans' exemptions, which are most commonly granted. To learn about all of the exemptions for veterans and what family members are eligible for them, click the button to view the exempt persons, applicants, veterans table in Chapter 7 of the Course 101 Handbook. Clause 22 provides a $400 exemption to the following individuals: veterans with a service-connected disability rating of at least 10% or more, veterans awarded the Purple Heart, Gold Star parents, and spouses and surviving spouses of Clause 22 veterans. Surviving spouses of some active duty military personnel, National Guard members, or veterans may receive a full exemption of their taxes on their domiciles under Clause 22D. While on active duty, the service member, Guard member, or veteran must have sustained an injury or contracted a disease that was the proximate cause of the death of the member or veteran, or be missing in action and presumed dead. The surviving spouse must have been domiciled in Massachusetts for the 5 consecutive years immediately before the fiscal year the spouse applies for the exemption, or his or her deceased spouse must have been domiciled in Massachusetts for the 6 consecutive months immediately before entering the service. The 5-year requirement may be reduced to 1 year if the legislative body of your city or town has accepted this local option. Note that remarriage ends this exemption. Veterans may receive a $1,000 exemption of the taxes on their domiciles under Clause 22E if they have a 100% service-connected disability rating. If the veteran's domicile is owned by the veteran's spouse, spouse qualifies for the exemption. The veteran's surviving spouse also qualifies even if he or she has remarried. Veterans may receive a full exemption of the taxes on their domiciles under Clause 22F if they are paraplegics as a result of a service-connected injury, or have a 100% disability rating due to a service-connected blindness. As with the Clause 22E exemption, the veteran's spouse qualifies if the spouse owns the domicile and the surviving spouse qualifies even if remarried. Veterans must provide certification of this service-connected disability from the VA or branch of service from which the person was discharged in the first year the exemption is sought. Veterans who qualify for a Clause 22E exemption must submit a current VA certification with each year's application. Once any other exemption is granted, however, the veteran does not have to include a certification with applications in future years unless the disability status changes. For applications by a surviving spouse of a disabled veteran, a certification of the veteran's disability at the time of death must be provided in the first year the exemption is sought, only if the veteran was not already receiving the same exemption at that time. A taxpayer who is legally blind is eligible for an exemption on the property owned and occupied as his or her domicile. The exemption is $437.50 under Clause 37. If the city or town has accepted local option, Clause 37A, the exemption is $500. As stated earlier, a certificate from the Massachusetts Commission for the Blind must be filed annually with the taxpayer's exemption application. In the first year the taxpayer applies, a statement from a doctor that the taxpayer is legally blind may be submitted instead. Now, let's review Clause 18, the hardship exemption. You may grant a partial or full Clause 18 exemption to a taxpayer you determine does not have the financial resources to pay all or part of their taxes for one of two reasons. The first is that the taxpayer is unable to pay because he or she was activated to military service, which reduced his or her income. The second is that the taxpayer is unable to pay because he or she is aged, infirmed, and poverty-stricken. That is, the taxpayer is an older individual who is disabled or ill and has limited income. Unlike other personal exemptions, Clause 18 exemptions are discretionary. You may establish criteria for what constitutes inability to pay and policies for granting the exemption. You must exercise your discretion in a way that is not arbitrary. That is, you must treat similarly situated taxpayers in the same manner. You may grant a Clause 18 exemption to a taxpayer who receives another personal exemption or defers some taxes. Seniors 65 and older may defer payment of taxes assessed on the real estate they own and occupy as their domiciles. They must also meet durational ownership and domicile requirements and have gross receipts within certain limits. Please review the list of qualifications. Note that the applicant's gross receipts cannot exceed $20,000, and if the applicant is married, the combined gross receipts cannot exceed $20,000. However, the legislative body of the city or town can increase the gross receipts limit up to the income a senior who is not a head of household can have in order to qualify for the state income tax circuit breaker credit. A property tax deferral is not a true exemption in that it does not discharge the tax obligation. Instead, it delays or postpones payment until the senior sells the property or passes away. A deferral allows seniors to use financial resources that would go to pay taxes for current living expenses instead. Taxpayers who qualify for personal exemptions under other clauses may defer all or part of the balance of their reduced taxes. The taxpayer must file an annual application like an applicant for a personal exemption. In the first year the applicant qualifies, you must grant the deferral if the applicant enters into a written deferral agreement with you and any co-owners or mortgagees have given written approval for the deferral. The reason is that the ownership interests are encumbered by the lien, securing repayment of the deferred taxes, plus interest. Repayment of the taxes has priority over their interests. You will then record a statement at the Registry of Deeds to continue the lien that exists on the applicant's property by law to secure payment of the deferred taxes. Interest at 8% accrues on the amount deferred each year. Your city or town can reduce that rate by vote of its legislative body. You may also grant a full or partial tax deferral to taxpayers experiencing temporary financial difficulties for up to 3 consecutive fiscal years under Clause 18A. Taxpayers eligible to defer under Clause 18A are those you determine currently lack the financial resources to pay their taxes because of a change to active military duty or other reason you determine, for example, unemployment or illness. You should establish appropriate policies and criteria to ensure that similarly situated taxpayers are treated equitably. As with the Clause 41A senior deferral, the taxpayer must enter a written deferral agreement with you and must have prior written approval of all co-owners and mortgagees. You will also record a statement at the Registry of Deeds to continue the lien that exists on the applicant's property by law to secure payment of the deferred taxes. Interest at 8% accrues on the amount deferred each year. Your city or town can reduce that rate by vote of its legislative body. Unlike the Clause 41A deferral, however, the deferred taxes plus interest must be repaid with the first of up to 5 annual installments due 2 years from June 30th of the last year of the deferral. If you deny a taxpayer a hardship exemption under Clause 18 or hardship deferral under Clause 18A, the taxpayer can bring a civil action in the Superior Court or Supreme Judicial Court. The action must be brought within 60 days of your decision. To prevail, the applicant must show that your decision was unlawful or arbitrary or capricious. Because you have discretion under those two clauses, the taxpayer cannot appeal to the Appellate Tax Board. As a general rule, a taxpayer may receive only one exemption. If a taxpayer qualifies for more than one, you would grant the exemption that provides the greatest tax reduction. There are some exceptions. A taxpayer who receives a personal exemption may also be granted a Clause 18 hardship exemption or Clause 45 exemption for solar or wind-powered improvements to the property. In addition, a taxpayer may receive a personal exemption and defer the balance of the tax if he or she also qualifies for a Clause 41A senior or Clause 18A financial hardship deferral. What if more than one person owns the property and qualifies for personal exemptions? As a general rule, if co-owners qualify for different exemptions, they may each receive their exemption. This rule was established by the case of Descenzo versus Assessors of Framingham. In that case, one co-owner qualified for a veteran's exemption and the other a blind exemption. If the co-owners qualify for the same exemption, however, then only one co-owner may receive it. There are two exceptions. The first exception is for spouses who co-own their domicile and qualify for a Clause 22 veterans exemption. Clause 22 states that each spouse may receive the exemption. The second exception is for co-owners who are not married to each other and qualify for a senior exemption under Clause 41 or Local Acceptance Clause 41B or 41C. Each co-owner who qualifies receives a proportionate amount of the exemption. For example, if the co-owner has a 25% ownership interest in the property, that owner would receive an exemption equal to 25% of the exemption amount. The Commonwealth reimburses cities and towns for some of the revenue lost due to personal exemptions. You must report the exemptions you granted to the Division of Local Services each year in order for your city or town to be reimbursed. You submit the report to the Municipal Data Bank through the DLS Gateway. You should submit the report as soon as possible after all exemption applications have been processed, but the last day to submit for reimbursement is August 20th. Reimbursements are subject to annual appropriation in the state budget, and any undistributed balance reverts to the state's general fund on August 30th. To learn about the amount reimbursed for each exemption, click the button to view the Exempt Persons State Reimbursements table in Chapter 7 of the Course 101 Handbook. Cities and towns may grant an additional exemption to all taxpayers who receive a personal exemption. To do so, the city or town must accept General Laws Chapter 59, Section 5C and 1/2. The legislative body must also vote the percentage of the personal exemption that will be granted as the additional exemption by July 1st of the fiscal year it will take effect. It may be set at any percentage up to 100% of the personal exemption amount. The same percentage must apply to all personal exemptions. The additional exemption cannot reduce the applicant's tax to less than the tax owed for the previous fiscal year or the tax owed in the current fiscal year on 10% of the fair cash value of the domicile. In this example, a taxpayer qualifies for a $500 Clause 41C senior exemption. The city or town adopted a 100% additional optional exemption. That means the taxpayer could receive up to another $500 exemption for a maximum reduction of $1,000. However, the additional exemption cannot lower the tax due below last year's tax due after the Clause 41C exemption. Last year's net tax due was $1,700. That means that this year, the taxpayer may receive a $100 additional exemption, which, combined with the $500 Clause 41C exemption, leaves a net tax due of $1,700 for the current fiscal year. This lesson provided an overview of the exemptions available to homeowners who have personal circumstances that the legislature has determined warrants a full or partial reduction in their taxes. In this lesson, we discussed that a personal exemption is a reduction in taxes due to a particular personal circumstance. We looked at some key terms and definitions and reviewed the guidelines, financial tests, and application requirements that taxpayers must meet to qualify for exemption. We reviewed the many types of personal property tax exemptions, including those for seniors, surviving spouses and minor children, persons experiencing financial hardships, veterans, blind persons, and surviving spouses and minor children of firefighters and police officers killed in the line of duty. We also reviewed the taxpayers who may defer payment of property taxes. Finally, we discussed the Commonwealth's reimbursement for some of the revenue lost by a city or town due to personal exemptions. To learn more about this topic, click the button to view Chapter 7 of the Course 101 Handbook, including the Additional Resources page. Please review the key takeaways